Good evening, viewers, and welcome to my channel. If you are watching outside the club, kindly subscribe and help my channel grow. To subscribe is free of charge. You can be a member of the channel by joining from as little as 14 rands. Hit that super thanks button and donate to my channel so that I can buy equipment for the studio. Going inside the Pretoria High Court, Nxumalo rose as the first defense advocate to address the Section 174 application. The courtroom fell silent as he laid out his strategy: strip the state's case down to its bare bones and demonstrate that without its key evidence, no conviction can stand. Nxumalo stressed the significance of being the sole applicant. While three other co-accused awaited their turn, only accused No. 4 challenged the sufficiency of evidence. This move reframed the discharge bid not as a procedural tactic, but as a direct indictment of the prosecution's case. He then targeted Constable Zungu, only eyewitness claiming to have seen Mafiza in Vosloorus on the day of the murder. Nxumalo catalogued Zungu's shifting accounts of time and place and suggested the witness harbored an axe to grind. Stripping the testimony of its reliability, that's where things stand after Advocate Nxumalo's Section 174 submission. Will the courtroom shake under the weight of his challenge, or will the trial march on? Subscribe and hit the bell to stay updated as this landmark case unfolds. Stay tuned and watch Nxumalo dismantle Zungu's evidence. Thanks for watching. Bye.
In State vs. Mpeta and others, 1983, Volume 4, SA 262, capital letter C at 265 D to G, Williamson J. held that relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it. Close quotation. Therefore, to summarize the legal position regarding application in terms of Section 174 is as follows. An accused person is entitled to be discharged at the close of the case for the prosecution if there is no possibility of a conviction other than if he enters the witness box and incriminates himself. B. Credibility of witnesses' evidence is only an issue where it has been the effect that the evidence is so unreliable that it can be said that no evidence has been adduced. C. Where the evidence of the state witnesses indicating the accused is of such poor quality that it cannot be relied on, and there is accordingly no credible evidence on record upon which a court acting carefully may convict, an application for a discharge should be granted. D. An acquittal must be in the interest of justice. E. Circumstantial evidence in the state case may be a relevant factor in deciding whether a case against the accused is so strong that it calls for a reply in the witness stand. It is against this legal background that I find it prudent to refer to the portions of the evidence of Zungu in the record of the proceedings and later proceed to analyze his evidence. Constable Sikumbuzo Zungu testified that he was a constable employed by the South African Police Services with 12 years experience under the invisible policing station at Sebenza Police Station. He knows all the accused before court. He knew Mthokoziseni, accused number 4. He remembers him from Vosloorus, but not back home. On the 26th of October 2014, he received a call from Gwabeni. Gwabeni wanted to know him, from him, that is Zungu, whether he was able to come to Vosloorus on that day. He responded that it was still early because it was around 7:15, and that on that day he was still going to work. Gwabeni called him again and informed him that there was another brother of ours, Makosonke from Rustenburg. He informed him that Makosonke was also going to be joining us. He knocked off and contacted Makosonke Zungu. He informed him that he was at Johannesburg at Carlton Center. That is where he will find him. He went there and found him. They arrived at a hostel between 2 to 3. He will not be able to remember the exact time. It is against this background that I will proceed and analyze Zungu's evidence. According to the version of the state, the only witness who met and placed the accused at Vosloorus Hostel on the 26th of October 2014 was Constable Zungu, Constable Zungu, who was a single witness. It is tried law that a court should approach the evidence of a single witness with caution. The following passage from the judgment of the Phyllis J.P. in R. vs. Mokoena, 1932 OPD 79 at page 80 is frequently cited. I quote, "The uncorroborated evidence of a single competent and credible witness is no doubt declared to be sufficient for a conviction. But Section 284 of Act 31 of 1917, that is the predecessor to the Act 51 of 1977. But in my opinion, that section should only be relied on where the evidence of a single witness is clear and satisfactory in all material respects." Close quotation. Instead, versus Weber, 1971, Volume 3, SA 754, capital letter A in bracket, the appellate division stressed that there was no magic formula which determines when the evidence of a single witness testimony may warrant a conviction in every case. What may be said, however, is that the evidence of a single witness has to be approached with caution. His or her merits as a witness must be weighed against factors which militate against his or her credibility. Thus, the mere fact that he or she has an interest or bias against the accused will not of itself obviate a conviction. It is necessary to assess the intensity of the bias in the light of the totality of the evidence. Close quotation. Corroboration. Instead, versus Jangley 2005, Volume 1, in bracket SACR 420 at 430. Clute JA, in dealing with the approach to be followed by a court when it is faced with a situation where a court should caution itself in analyzing the evidence, said the following, I quote, "It must be emphasized immediately that by corroboration is meant other evidence which support the evidence of the complainant and which renders the evidence of the accused less probable on the issue in dispute." Close quotation. It is clear from the authorities that if corroboration was required, if it had, for purposes of the so-called cautionary rule, to be corroboration implicating the accused, and not merely corroboration in the material respect or respects. The evidence of Zungu was not corroborated in all material respects. Skhumbuzo Zungu was not called by the state to corroborate the version of Zungu, insofar as traveling with Zungu to the hostel after he had received a call from Gwabeni to pick up Skhumbuzo Zungu at Carlton Center in Johannesburg. Zungu is the only witness who met the accused at Fosora's hostel. He was introduced to the accused by Gwabeni. It is surprising that this introduction was done to this witness when Zungu and the accused knew each other. Zungu testified that he was requested by a certain gentleman, that is accused number 5, was requesting him to remove his vehicle because he had parked behind the vehicle that accused number 5 was traveling. Zungu and others he was seated with went to buy liquor and they drove using an Uno motor vehicle. He was traveling with accused 2, accused 3, and the driver. There were 5 in total. From the body of Zungu's evidence, this is the only time that he had traveled with accused 2 and accused number 3. In his affidavit dated the 23rd of May 2023, which was obtained some 4 years later after Brigadier had taken over this investigation, page 2, paragraph 4, line 10 to 11, Zungu states the following, and I quote, I must also at some point went out to the shops to buy some alcohol and drinks with a certain lady and came back to Gwabeni's house. Close quotation. It is clear that Zungu does not place the accused, that is accused number 4, traveling together using the VW Polo hatchback grey in color that he alleged accused number 5 was using, leaving the hostel, and part of his evidence is that he saw accused 1, 2, and 3 coming in, following each other, going towards Gwabeni's room, and he followed them. Inside the room, accused 1 was in possession of a .38 special revolver, and accused number 3 was in possession of a 9mm pistol. Accused 5 came inside the room. He was followed by accused number 4. Zungu states the following at page 2, paragraph 5, line 1 to 3 of his affidavit, and I quote, "Around 9 p.m. on the very same day, I noticed Moses Spear Mafiga, open bracket, Sandy Sontanzi, close bracket, and Kani, open brackets, Fisokuhle Zungu Ntuli, close bracket, walking after each other to Kwabeni's bedroom from outside. He does not mention accused number 4, following accused number 5 to Kwabeni's room. At page 2 of his affidavit, paragraph 5, line 6 to 9, he states the following, and I quote, "I saw Moses giving Kwabeni a .88 special firearm and Kani giving Kwabeni a 9mm firearm," close quotation. At page 2 of his affidavit, paragraph 5, line 20 to 21, he states the following, and I quote, "Mthoziseni Mapisa and Carlos Ncube walked into the bedroom and sat on the bed," close quotation. There are material contradictions between Zungu's evidence in chief and his written statement. The correct approach to any contradiction between the prior statement and the witness's testimony was, in respect, most useful, summarized by Olifield J.A. Instead versus Mafala Fidiso in another, 2003, volume 1, SACR 583 SCA. The head notes in that case is submitted accurately, reflected, was said and was cited by Nechben J. Instead versus Governor and another, 2006, volume 1, SACR 322, capital letter E in bracket. In respect of the factual evidence of Zungu's evidence, the contradiction are material and affect his credibility. During cross-examination by Mr. Ramsepel in respect of Zungu knowing accused 2, this is how Zungu responded, and I quote, Mr. Ramsepel, "Now, accused number 2, because I will chop and change with respect to accused 1 and 2, but accused 2 himself says he does not know you in total. He just see you here yesterday in court, Mr. Zungu. If that was said or was coming from accused 3, 4, and 5, I would have agreed with you. Okay, where I was born or back home, where I was born, or he is Ndanzi. It is clear from Mr. Zungu's evidence, when question is posed to him by Mr. Ramsepele in respect of him knowing accused number 2, his response was that if that was said by accused 3, 4, and 5, that they do not know him in total, he was going to agree. The response by Zungu is a clear indication that he did not know accused 4, in the light of the fact that he says he was going to admit that he did not know accused 4 if such assertion was put to him by accused number 4. During cross-examination, Zungu testified that a typed version of his statement was made out of notes that he had written himself. And where there are contradictions in paragraph 5, he actually meant accused 4 and 5 entered Kwabeni's room and not accused 3. During cross-examination by Mr. Ramsepele about Zungu mentioning in his written statement that he went to Top Spa to buy liquor in the company of a lady, this is how Zungu responded. Mr. Zungu, I think maybe it is a manner in which it is put here, but I did go to Tops with the gentleman. We came back and then there is a lady that just want to go nearby, who had requested me to buy her a drink, and I did go out with that lady. In his evidence in chief, Zungu testified that the person wearing a cap was accused number 2 when he was confronted that in fact the person wearing a cap was accused number 4. He could not proffer any explanation. Zungu testified that at some point he met Brigadier Shabane, who informed him that he was going to conduct his own investigations, and thereafter he will come back and inform him, but did not tell General Leshabane that he was at the hostel. The reason was that he did not want to give General Leshabane this information, that it was coming from him, and that he did not have certainty with regard to that. Clearly, Zungu had an axe to grind for the accused when one considers the compactness of his evidence. Zungu testified further that on the 13th of November 2013, he had a meeting with Brigadier Gininda. Brigadier Gininda asked him what he knew about the killing of Senzo Meyiwa. He told Brigadier that he knew nothing and there was nothing that he can talk about. Brigadier Gininda told him that he was going to do his own investigations. At that meeting, Brigadier Gininda was with Brigadier Tony. Zungu testified that the relatives of accused number 1 wanted to shoot him. He spoke to accused number 1 over the phone and asked accused number 1 why his relative wanted to shoot him, because he, Zungu, also did not know anything about this matter and did not know anything. It is clear, my lord, that from the responses or the evidence of Zungu, he mentions that not even on one occasion that he did not know anything about this case. He said this in the presence of General Leshabane. And on the 13th of November, when he had a meeting with Brigadier Gininda, he repeated the very same assertions that he did not know anything or knew nothing about the killing of the deceased. Thirdly, he mentioned this when he spoke, as he said, to accused number 1, when he was making inquiries about why his relative wanted to kill him, because he did not know anything about this case. Further, to proceed, Zungu could not explain what was the occasion on page, I'll come back to that, of Exhibit C, despite claiming that he was with accused 3 and 4 on the day of that occasion, the date of the 26th of October, 2014.
But you're saying Zungu's evidence is not corroborated in any of the evidence left in this court?
Yes.
Never.
Never.
Remember, what's the time they say?
It's 11, facing a lot.
Yeah. You remember there was evidence by Buthelezi, a gentleman called Buthelezi, who went to see accused number 1 to give him some washing items. Sorry, number 2, yeah, you're right. In Rustenburg, next to some supermarket there.
Yes, I remember that evidence, my lord, very well.
Yeah. And then there's another piece of evidence. I don't know if it's accused number 1, who was drinking Irish whiskey and exclaimed that Senzo is no more, Senzo is no more. You don't remember that?
I remember that.
Okay, on that note, let's go and have 3.